Okay, hello everyone. My name is Aaron Olajide. I'm a project lead at the ILCA, leading growth in partnerships. As one of the fastest growing community of technology law specialists in Africa, we pride ourselves in bridging policy, literacy, and collaboration gap in the technology law space in Africa. And so this evening, we are very opportunate to have Patricia Mumuni, a partner at ENSafrica in Ghana, who is going to be taking us today on transaction management. Just to mention, this particular session is part of a series of masterclasses we're having for our current fellows at the ILCA. And we're just super excited to have Patricia on the call with us today. Hello, Patricia, how are you?
I'm well, Aaron, thank you.
Thank you so much. So I'll allow Patricia to go ahead with the presentation and wish everyone a great time.
Thank you, Aaron. So I'd like to introduce myself. As I said, my name is Patricia Mumuni, and I work with ENSafrica Ghana. I've been practicing for a little over 9 years. I'm in my 10th year now. And my area of expertise is corporate commercial. Corporate commercial, as most of you would know, is a very wide, very broad area, which includes fintech, like Aaron just mentioned. I do so many things. I advise on employment law matters. I do mergers and acquisitions. I do corporate governance. It's just a very broad range of things, intellectual property, a bit of tax, not too much, just the very basic things on tax. And so with ENSafrica, we are structured, we have 3 teams. I'm part of the corporate and commercial team, and that's led by Amina Kagwa. She's also the head of country. We have a finance and energy, mining, and infrastructure team. That's one team on its own, which is headed by Patricia. We also have a corporate commercial disputes resolution team, which is headed by David Isedu. We have about 24 lawyers in the Accra office and about 10 non-lawyers who assist with our business services. And so that's really a summary of ENSafrica and myself. If you want to know any other thing, you can please feel free to ask. But for now, I think that is what I've given is relevant. And so I chose a topic, as you would see on your screen. Transaction management, because I didn't want to limit or do something that would require me to speak only about Ghanaian law. I wanted something that anybody participating in this session can walk away with, that they can apply, whether they are a solicitor or a barrister. It's something that you can apply in even if you're not a lawyer, and you are an employee or even a business owner. There are 1 or 2 things that you can walk away with that I can guarantee would certainly improve the way you work and your outputs and your efficiency. And so the topic is transaction management. Let me move on to. Okay. So as I said, the purpose of this training is really to tell you what I have been doing really over the past few years and how that has benefited me and improved my work and my efficiency and made me stand out in what I do. So this presentation, even though I've done some research, is really based on my personal experience and the things that I think you may consider doing that may improve the work that you do generally as lawyers. And so what we will be doing is to look at the different transactions that we have, the different things we do as lawyers. Somebody may see the word transaction and think that, oh, must be an acquisition or some sort of merger or some big transaction. anything at all, even if you're a barrister, you go to court and just argue cases, you're a litigator, and you don't do corporate commercial work, the work that you do for your clients, no matter how small you look at it, no matter how little it is, no matter how big it is, can be looked at as a transaction. And we are using transaction here very loosely and broadly. And I do that because when you look at things, whether they are small or whether they are big, when you look at it in a certain way, your approach to it will be the same. So if it's a big M&A with big clients on there, you approach it the same way you're going to approach your work when it comes to your smaller clients, whether it's an SME or it's just an email that you are responding to, you approach it the same with all the seriousness that you require or it demands of you. And so that's really what we will be looking at. And so, as I said, the transaction, there are different types, okay? We have mentioned some of them already, the big M&As that we do, the mergers and acquisitions that we do, the due diligence that we do, the share purchase transactions that we do, the share issuance or the subscriptions that we do, the restructuring, business restructuring that we do, the schemes of arrangement that we do, the different redundancies that we have to advise on. All those things can be seen as transactions, and your approach should be the same when you're going into these things. And if you have a standard way of doing things, you are more efficient. When you get work, you know how to go about it, what to do first, and that makes life generally easy for everybody. And so you will see the things that I've written here. We have the share purchase, I talked about the due diligence, we talked about the asset purchase, the restructuring, the scheme of arrangement, redundancy, setting up, obtaining a license or some sort of regulatory approval. Each and every one can be looked at separately. They can stand on their own. Sometimes they come as one big transaction where you find an M&A or mergers and acquisitions, or let's say an acquisition where you have a share purchase, you have to do a due diligence, when you're done, you have closing matters that you need to attend to, like filings and all that at the company's registry, approvals that you may have to seek from regulatory authorities. And you can look at all that as one big transaction. Also, you can break them down as little transactions on their own. Clients may come to you and not want you to be involved in the entire process. They want you to do just a part of it. And so these are the different transactions that I have seen as a corporate and commercial lawyer. If we stretch this to a litigator, for instance, if your clients came to you and said, look, I have this contract and it appears that there's a dispute with between the parties. I'm the supplier, this other person, I supplied some goods to this other person and there's been a misunderstanding. And you look at the contract and you see that, look, the dispute resolution mechanism in that contract is arbitration. That's arbitration that you'll be taking part in or representing your client in. It's a transaction on its own. You may look at it as going to court, but it is a transaction. And so your approach to it, it shouldn't matter whether it's a big client or it's a big arbitration or it's in Ghana or it's in London. It shouldn't matter. Your approach to it should be similar. You should go into it with the same seriousness as you go if it were a smaller client or a smaller file case. So the different stages in the transaction, being a corporate and commercial lawyer, when a client comes to me, and I don't know about how other firms work, but most of you would know that ENSafrica has many offices across the continent. Accra or Ghana is one of the offices that ENSafrica has. And so when we get instructions or when we are approached by clients, a client comes and wants you to do something for them or advise on a transaction, what we would do first of all, before even accepting the the instructions, or even sending a fee quote for to do the work, is to make we are not conflicted. And conflicts and I'll break it down, I'll bring it to those who have smaller firms. Okay, so ENSafrica, we conduct a conflict check where we send it to everybody in Africa, and everybody is supposed to look at it to make sure that the people that we seek to act against are not clients or already existing clients of the firm. Because that could end up being a very messy situation, right? If you're acting for one client against another client that you've already acted for in the past, that could be problematic. And so for the smaller firms, if it's a small law firm, if you receive instructions, the first thing you should do is to check if anybody in the firm, because different firms run different structures, okay? You need to find out if anybody has used or has represented that client before. And so you need to be keen on it. I quite remember not too long ago, and my husband is a lawyer, and so I can share this. So in his law firm, somebody came, and they ran a small law firm. Someone approached him wanting him to do a case for him. And he looked at it, ready to take it, only for him to find out at the very last minutes that his supervisor in the firm had already acted or was acting for the other party on the other side. And so being in a firm like that, if you're acting, your supervisor is acting for the other party, you acting for this other party, it just wouldn't work. As a firm, you need to have one face and represent one person, okay? And so for that instruction, he had to turn it down. He could not, because his boss was already representing the counterparty. There's something we call Chinese walls, which I'm not sure, I'm sure people know what Chinese walls are. So for a large firm like ours, we're able to create Chinese walls, and we've done it a countless number of times, so that if we will be conflicted in acting for a counter, for a client, because we've acted for the counterparty in the past, or that the counterparty is our clients, what we would do is create Chinese walls. And that means that we are going to get different teams within the firm. So within the corporate and commercial team, we would take one client, maybe the client that we already know, and then the other team, maybe finance team, and we have one that's live right as I speak. The finance team will take the other party and ask for the other party, and they will take the other party on the basis that they do not know anything about the party that we are representing. They have not done any work for them. They don't have any prior knowledge about them. So we create a certain a wall, some sort of virtual wall, where one section of ENS does not know about the other clients. So both clients are clients, the firm's clients, but one group or departments within the firm asks for one, and the other asks for the other. And we don't exchange information. We don't discuss the transaction. We act as if we are two different lawyers acting for two entirely different clients. And we've had instances where clients come, they are counterparties to clients, and they tell us, look, it's okay, we don't mind you representing both of us for the same transaction, because we trust that you act in our best interests. And so for such situations, what you do is to get a confirmation that they are fine with us acting for both of them. Because if you make a mistake, what's going to happen is that you can be sued, or they can report you to the General Legal Council, which is the council that regulates lawyers in the country. And you don't want to be disbarred, or you don't want your license to be suspended or withheld or anything of that sort. And so we try to do some of these things. And when two clients come and they want us to ask for them, we will get some sort of written confirmation from them. when you're approached by a client is to do a conflict, explain the conflict check. If anybody has any question, please feel free to ask. I may not see your hand up, so just cut in and I'll stop. And so when you do the conflict check and nobody comes back to you and says that, oh, this person that you are seeking to act against is our client, so please for them. And we've had instances like that where we've had to turn down instructions as ENS. You would typically send a fee proposal. And the fee proposal, it depends on what the client tells you. Sometimes the client will come to you, they know exactly what they want. They will come to you with an RFP or a request for proposal. And so they'll come, they've set out the scope of work, they've set out the transaction, the details, how the transaction is going to work. And so when it's like that, it's easy because you look at the scope of work and you just prepare your proposal based on that RFP they've sent to you. In other instances, a client will come to you without telling you, they'll tell you, oh, I want to buy shares in this company, or I want to buy 60% stake in this company. They don't know how to progress with the transaction or to implement the transaction. They tell you what they want. And so as a lawyer, it's up to you to develop the scope of work. And so if a client comes to you to tell you, look, I want to buy a stake in this company, what do you do as a lawyer? They don't tell you anything. If your client is a potential buyer, you should first of all know that, look, before your client takes up a stake in that company, you need to do a due diligence on that company and flag all the issues and tell your clients that, look, this company is indebted to the tax authorities to the tune of, maybe $1 million or whatever the amount is, or they have serious employment issues. If you look at their employment contracts, they are bound to have a lot of problems, or that they have a lot of litigation, many cases against them in court. So I won't advise you, even though the company may look good on the outside, I would not advise you to go and take a stake in that company because you end up not making any money. Because why do people invest? To make money. So if you're going to invest in a company that's heavily indebted, or a client that is not doing so well as it may look on the outside, then that's a stage that you tell your client after the due diligence based on your findings. You tell your clients can make a decision based on the findings. And so for you, if your client came to you and told you that, look, this is what I want to acquire shares, you need to set out the scope of work properly for your clients, that you do want a due diligence, as I said, and you, based on your findings, you know whether to proceed with an asset sale or a share sale, or you want to do a share issuance where the company will issue you shares, so you subscribe for shares in the company. So the due diligence stage is a very critical stage for a lot of, for some of these transactions. And you know what kind of agreements, transaction documents to put together. So at this stage where you are preparing your proposal, you should be clear, because if you are not clear in your mind as to the things that you need to do, what would happen is that you prepare your proposal, send it to the client, and along the way, while the transaction is progressing, things will pop up, and things will pop up that maybe your clients would expect that a lawyer of your standing or a lawyer of your stature should know, and you won't look good. So the proposal stage is a very important stage where you cover all the things that you are supposed to do for the transaction. And that would also show how well you understand the transaction. And so it's a very critical stage that a lot of people take for granted. And there's a difference. When a client comes to you, they want a fee quote. A fee quote would typically go in an email. Okay, you send a fee quote, and you may or may not have assumptions in that fee quote. One thing that a lot of people do is, so we'll say, okay, we'll charge you $2,000 to respond to the queries that you've sent to us. It's fine. One thing I've learned over the years is that when you are going back to the clients with a fee quote, try and put assumptions in there, because you quote $2,000 for 5 questions. You answer the questions. The client will come back with follow-up questions, about 10 rounds of follow-up questions. And you realize that the time you spent and the quotes that you gave to the clients, you far exceeded it. Okay, so for me, what I usually do is to give assumptions that, look, I'm going to do this work for you for $2,000, and the follow-up questions or queries should not exceed 3 rounds. So you know in your mind that it's just 3 rounds. So you can come back with follow-up questions just 3 times. And if you exceed that the 3 times, I'm going to charge extra for that. And so that's something that we need to be mindful of, even with the platform. So even with the court-going lawyers, the litigators, it's something that you need to keep in mind that, look, we are going to take up this case. Somebody is unmuted. Does someone want to speak? Okay, so even with the litigators, when you're charging your clients or you're giving quotes, you need to keep in mind, sometimes the cases will prolong and prolong and prolong. If you go and charge a certain fixed fee, look, within 2 years, you would have spent all that money, and the rest of the 3-4 years that you're going to court, it won't be beneficial to you. So you need to be mindful when you're giving quotes for the litigators. So with a fee, so we send a fee proposal, we send a fee quote, and as I said, the proposal, we have an in-house document that we use as our proposal, and the proposal would typically have, as I mentioned, something about ENS, a profile of ENS, our rankings that we have, our relevant experience. So if someone comes to you, they want to set up in Ghana, our relevant experience will be in that area. So we'll give them our experience in setting up. So we'll tell them, oh, we set up for this person, we set up for this person, we give them a long list. So it's relevant. We don't just put any relevant experience there. It should be tailored for what the client has asked for. So you have the relevant experience. We also have the scope of work. I told you that I would typically put assumptions. Assumptions are a lifesaver, so please take that seriously. Have assumptions in your proposal. Sometimes we'll put the team and we'll put their series in there. Other times, if clients don't ask, we will typically just put the names of the people who we would put together or constitute the team for the transaction. And if it's just a quote, it's just an email that says that we are able to assist at this amount of money, and that's it, really. And I'll put an assumption there, we send it to the client. And so when you do this, after you send your fee proposal, what happens next is that the clients will come back and say that, okay, we agree with your fees, we agree. And it's good to have timelines. When I realized, and from experience, I realized that when I don't agree timelines with clients, sometimes the work delays. But when I know that I have promised a client 5 working days, I promise to come back today, I'm going to do everything in my power to make sure that I go back to the client. And if I'm not meeting the deadline for some reason, I would send an email to tell the client that, look, we need to confirm a few things from the insurance commission, for instance, or the central bank. We are not getting that confirmation. So kindly permit us to come back to you on Monday. And so that is typically what I would do. But if I don't set timelines, I don't agree timelines with the clients, I realize that I don't pay so much attention because I know I have sort of an open check and I can go back to the clients at any time, but it's not the best. The best is to have a timeline, agree timelines with the clients. And if you are not able to go back based on your agreements, you go back and ask for permission. And so you do all these things, and then the client agrees, they instruct you. When the client instructs you, this is a second level of understanding the transaction. For the ones that we do a lot, the mergers and acquisitions, we do them a lot. Or if a client comes to you with employment-related queries or something on capital markets or private equity, whatever it is that the client comes to you with, you may have done it 1,001 times, so you would understand it. But it's still very important to read your instructions well. If you do not read your instructions well, you end up doing work. And that's why I tell my I tell my associates all the time that, look, if you read the instructions and you do not understand the instructions, you need to come to me. Do not wait and do something that will come to me and then we have to start all over again. Meanwhile, we have timelines that we are working with. So understanding the instructions from the clients is very important. Sometimes, we get instructions and you think that, oh, you want to give more information. More information is good, but you need to focus on what the client wants. If you give them more information, maybe it's just by way of further information, but you need to deal with exactly what the client wants, and then you can give further information. But the key points you need to walk away is understanding. It can be embarrassing if you don't understand your client's instructions and you do the work and you send to them and they come back and they're like, lawyer, this is not, what I requested. So you take your time and understand. And if you're an associate, if you read instructions and you don't get it, go to your supervisor and agree on the scope and your instructions, so that when you go and do something and you come back and that is not it, you cannot be blamed because your supervisor was in it, you read it, and you both of you agreed. And so if you're an associate, that is the way to go. Understand your instructions before you go and don't take anything for granted. Immediately you realize that, look, something is giving you two interpretations or more than one interpretation, or you see it in a certain way, it's best to discuss and do not wait till the very end. Let the work go to your supervisor, and then your supervisor is reviewing and this bad. And this thing, I am looking at it, and then you say, oh, when I was doing this, that's what I was thinking. Why didn't you go and ask your supervisor at the time you were doing it? And so that's something that I think that we all need to do. I'm a partner, but I have senior partners. And so when we have tough instructions that, needs brainstorming, I won't sit and wait, send the work last minute. I will go and speak to the senior partner, and then we'll brainstorm together, find a way, solution, an agreed solution or a way forward before I start executing my task. And I think that will help everybody on here. So once you understand your instructions or you understand the transaction, and you would know what kind of research to do. And let me backtrack a bit. Understanding the transaction and the research, let me stick to with the research, it's not about just legal stuff. As lawyers, we tend to focus a lot on the legal things that we do. A law, this section, this, no. Sometimes just understanding the industry in which you're advising on, okay? If you are doing mining work, and it's employment related, but the employees are employees of a mining company, your approach should be different from a regular company that's not in a regulated space, because the mining sector is a totally different ball game where you have unionized employees and it's different. So you need to understand the industry in which the clients is to. Let's not just focus on the legal aspects. And one thing that helps a lot is to be commercially pragmatic. Let's not stick, because that's and it's an evolving thing, and it looks like that's the future. And if you come to Ghana and even in Nigeria, where it's a bigger market, and you go to South Africa, what distinguishes the top law firms from the smaller law firms is the commercial pragmatism. We try to solve problems. And so for you, in your research, in everything, your work, everything that you do, look at it as you solving a problem for a client, because a client always comes to us with problems. And so if the law is going to solve the problem, you state the law. If you have any industry practice, state it. If you've spoken to a regulator, state it. Let them know. Let them have like the bigger picture. Consider the law, because sometimes you look at the law and the law doesn't. It says you look at a law and the law was passed in 1970, and you are looking at your current situation and you see that the law and what is happening in practice presently, they don't. It doesn't even. They're not commensurate. And apart from that, you realize that even the regulators don't implement the law the way the law is stated in the law, because it's an old law. and maybe times have traveled past. And so if you are doing your research, don't just stick to the law. Your research should extend to regulators. Your research should extend to what happens in practice. And when you give your clients work like that, they'll come to you very, very happy. We already talked about the communication with the clients, the fact that if you are not meeting your deadline for one reason or the other, look, you need to go back on time to your clients that this is the reason you are not coming back to them. They should allow you to come back. And usually clients are nice. They'll tell you, okay, it's fine. And please, when you go for an extension like that, make sure that your second deadline you would meet. So you do that. And also in communicating with your clients, remember that if you're doing the work, you've received instructions, you've had several calls with your clients. If there's something that's still not clear to you, do not hesitate. Don't be shy to go back to the client and ask. Because sometimes we underestimate our clients. Some clients are really intelligent, and they know the industry. They may not know the law, but they know the industry well. And if you take your time and you listen to them, you learn a lot. And so if you are doing work and you need to go back to the client, please do not hesitate. It's something that you need to do. You can call them. One thing that works really well for me is calls. I prefer emails because that is something that you can verify, right? Because the email is there and you can go because the client said yes. And so you can pull the email up and it's there. But if you spoke to a client and they said yes, and tomorrow they said, but I didn't say that. Well, how do you prove that? But I still like it. I like it because what I would typically do if I spoke to a client, I will send an email after to the client that, oh, we spoke. And this is what you said. Thank you very much for indulging me or speaking to me. So I have it captured in an email. The client will typically come by, oh, you're welcome or something. Then you have it. But it's easy to get to them because if you send an email, that may take a bit of time. So you get them quickly on the phone and you follow up with an email. That will be helpful. And also about the delivery, you talked about timelines, your work, the quality of your work. And I don't know about other law firms, but if the ENS style is really to have work in very simple, the language that we use, or if you look at our memos, our opinions, we use very simple language. You wouldn't see as quoting section 8 of this says that the client does not care about section 8. The client wants you because section 8, anybody can take section 8. But it's not everybody who can interpret section 8 accurately. So as lawyers, what we need to do, if you take a section 8, you need to break it down for your client. What does section 8 of the Companies Act say? Please break it down. Don't go and lift and the company shall have 2 directors and 1 director shall be, no. Break it down in simple language all the time for your clients. We have a client, we did some work for Nigerian sometime this year, and the feedback we got was so nice. He said, look, I read this opinion that you sent and I understood everything. And for us, is gratifying for your client to say, I read it, it wasn't technical, I understood everything. That is what we aim for. And that's what lawyers should aim for. I think in the past, we used to scare the clients with the big, the legalese and the Latin, and the practice of the law has moved from that. And it's not so scary. Clients right now appreciate very simple language for them to understand what the law is. So the clients will take the law and will not interpret it the way you have. So your job is to interpret it nicely in very simple language. So try that. And there are lots of writing skills that you can learn, just writing in simple language, drafting in simple language, writing skills. You can go to Google and find different articles and stuff that you can read on how to write simply. So that's one thing. And so we send the work. So you send the work to your client. The next thing is, how do we make money? I don't know about other law firms, but with ENS, and we have a system where we record our time, right? And so we have different fee arrangements. You have the fixed fees, you have just different types of fee arrangements, okay? And so we have the hourly. So I can do maybe 5 hours and I'm charging maybe 1,500, or 5 hours and I'm charging $2,000 for 5 hours. So we have different fee arrangements. But the way we make our time is to record the time. So if you have a fixed fee arrangement, for instance, a fixed fee arrangement is not whether you do 10 hours or 20 hours, the fee is fixed. So if you do 2 hours but you've charged 2,000, that means you made a gain. But really, the point of this time recording is that if you're a lawyer and your firm has a system where they record time, you need to record your time on time, okay, promptly. And if you do that, you don't lose money, because you realize that if you wait till you maybe end of month before you sit down to do all your time, you capture everything, because there have been meetings, there have been calls, you may not have recorded everything well. And so you may have this, and I'm sorry, I was interrupted. You may have done the work, but if the work doesn't translate into money, we are not going to achieve anything. Why? Who's working for free nowadays? And so for us, how we make our money is to record our time. For other law firms, I don't know what is done, but if you record your time, you will be able to bill your clients and you will make money. If you don't have a system where you have to record your time, you have to record your time and generate invoices for the clients, that's a different thing. I'm sure people have different ways of coming by some of these things, and they've done it for many years and it's worked for them. So you don't have to have a system, but and we experience, a lot of us would know that, oh, if I'm taking matrimonial courses, for instance, and maybe a divorce petition, or a custody case, or an adoption, because of your experience, you know how much you will charge, right? So you don't have to really record your time for that. So people have different ways that it works for them. But for our firm, we have a system where we have to record our time, and that's how we make our money. And so these stages that I've gone through, whether you are a corporate commercial lawyer, whether you're a finance lawyer, whether you are a litigator or a barrister, it should work for you, okay? It may not apply 100%, but there are things in here that I've mentioned that if you follow through, you'll be fine, okay? So these are the different stages. So we move on to the next part of our presentation, which I think is the last or so, last but one slide, which is very important because it's not really telling us about the steps that you take when you get instructions or you're approached by a client, but the things that you need to do as lawyers, okay? The first one is being proactive. So if you're an associate and you are put on the matter, don't wait for your supervisor to keep coming back to you to instruct you. They will put you on the emails, and that's what we typically do. If you're an associate and you're on the matter, you will be copied on all emails. So when the email comes to you, I expect that you will see the email and run with it. If you're not clear on something, you come to me and ask and get direction or guidance. But I expect that you take the lead in the transaction. And if you're an associate and you're working with me, I expect you to own the transaction. Own it, it's yours. And when you own something, the way we treat our possessions, okay, if you have your house, your car, your possessions, I won't include, but if you have children, the way you treat your children, you own your children, you love them, they're dear to you. And if you are able to do this with your transactions, trust me, your clients will be happy with you all the time. and you get fulfillment in your work. So you own the transaction, and you know the transaction more than your supervisor, because you do all the legwork. When the work comes, when the instructions come, you do the research. You go and do the legal research. You find out what the regulator does in practice. You do everything. So when you own the work, and the supervisor needs something, they can easily, Femi or Abebi, can you tell me what's is in clause, or can you tell me what this transaction is about? And you know it. And the way you speak about the transaction will tell whether you are involved in the transaction or not. And so don't take it lightly. And your supervisors would assess you based on the way you do the work. So ownership is one of the most important things, whether you are a partner, or you're a senior associate, or you're an associate, or you're a trainee who was called to the bar. Own your work. Ownership means understanding your work. Ownership means taking it upon yourself to know every aspect of the transaction, that nothing can surprise you, that you be the go-to person when that transaction, your supervisor will defer to you on matters. When you do that, you feel proud of yourself, and it helps you your career progression as well. And people can trust that when they put you on transactions, they don't have to be chasing you all the time. They don't have to be the ones doing the work. They can rely on you. I'm sorry. So ownership and proactiveness is one thing that I think that you should walk away with. Having knowledge and all that. Look, everything here flows from ownership, because once you own your work, you have knowledge, you have an in-depth knowledge about it, and you're developing yourself to your expertise in that area. And so ownership and knowledge, knowledge would certainly flow from ownership. And you definitely have expertise in the area and be like the go-to person. So now, if you look at it, I don't know how the Nigerian market is, but there's a shift from generalization to specialization. Yeah, specialization, where we have people who are in the firm do employment matters. So when an employment instruction comes, not because we've tagged them as employment matters, but because over time we realize that they have such keen interest in employment matters. They go beyond what everybody does. They read the laws. They are very up to date with cases, judicial precedents. When they come, we know that, oh, this person will probably have this case or may have read this case. And so when work comes, we will give it to that person. We have data protection. We have people who are so good with it, not because anybody has done any special thing or said, oh, you do data protection, because they are developing themselves in that field. And so if you own work and you get work constantly in one area, for instance, you will be an expert in that area if you do it for a number of years or a number of transactions. And so ownership, being proactive, having knowledge, and just having a niche for yourself, or standing out in a certain area, okay, trying to get some expertise in a certain area, being known for a certain area of work. And you can do it yourself. You don't need to be prompted to do it. You can set a goal for yourself that, look, this is what I want to do. I like data protection work. I like privacy matters. I like the fintech space. I want to learn as much as possible in that area and develop yourself. Read. It's all about reading. And when the work comes and everybody knows that you are the champion, if you can do training for your firm or your team members, do it. Nobody will come and ask you. You can offer to do the training and show that you have some love for that particular area. Okay. So another thing is meeting deadlines, okay, and being responsive. We talked about being responsive in relation to clients, but, clientele, if you look at it, if you are a junior, you have to be responsive. You have to be responsive. You have to be able to associates and you are looking at who your client is, you look at it from internal first, and you can go external. So internally, who are your clients? Your client is your supervisor, because your supervisor is the one who sent the work to you. And so you have a duty to make sure that you meet the deadline, your supervisor's deadline. Externally, is likely that your supervisor will be the one interfacing with the client. So even though that the external client is everybody's client, is the firm's client, it won't be you interfacing. So for a lot of juniors, your client really is your supervisor. And you need to please your client. You need to make sure your client is happy, right? And so you need to communicate, you need to be responsive, you need to try and meet deadlines. And as I said earlier, if you are not able to meet a deadline, go back and negotiate for an extension if possible. And make sure that when you are going back, the extension that you are going to negotiate for is a realistic one, and that you would meet it, so that you don't have to keep going and asking for. And make sure you don't let it shouldn't be something that you do all the time, asking for extension. You shouldn't be known for asking for extension all the time. Because typically before you get the work, I would ask you, how many days do you think, or how many hours do you think you take to do this work? I already know, but I want to have a sense from you. So I would ask you, tell me, within 4 hours, I should be able to finish this. And you go, and 48 hours later, the work is still with you. It's not the right way. Okay. Another expectation is problem solving. We've talked about the problem solving, that as lawyers, we should see ourselves as problem solvers, that we don't just quote the law, but we solve a problem. If you're in court, if you're a litigator, or you're representing your client in an arbitration, you should know that you are trying to solve a problem. You are trying to get victory for you. You want to be successful in that matter that you are representing your clients on. If you're a corporate commercial lawyer, we are solving a problem. If your client wants to acquire a stake in a company, you are solving a problem by making sure that you do all the right things, all the necessary things, all the relevant things to make sure that your client achieves that purpose that they've set for themselves. If you are advising a client in an employment, maybe a termination or a redundancy, okay, you make sure that you follow all the rules of redundancy under Ghanaian law or Nigerian law, and make sure that your client achieves its purpose by laying off the number of workers it wants to lay off without any hassle or with as little trouble as possible. So yes, we solve problems. If you ask me, I would say I'm a problem solver, not even a lawyer. So if you have that in your mind, any instruction that lands on your table, you ask yourself, what is the problem? What am I supposed to do? How can I help the clients to achieve this? So if you look at yourself like that, you're going to be doing a lot of amazing things. And you see that creativity. A lot of the time, we need to think outside the box. And it's a challenge for a lot of lawyers. When we start practice, you realize that this is the law and we stick to it. I'm not saying you should do the right thing, always follow the law. But there are ways that you can interpret the law that will help your clients. There are things that you can do that would help your clients, even though the law is saying A, you can do A+, and you're going to solve your clients' problems. It should all be within the subject to law, within the ambits of law, nothing unlawful or illegal. But you need to be able to think outside the box, come out with ideas, things that you can bounce off options. Clients love that. Okay, I want to do this. Oh, consider this. Or have you considered this? They love that because you are thinking about them. You know their business, you know their industry, and you are looking for solutions for them. So that's something that you need to keep in mind too. And time management, whether you find yourself in a litigator or you're a corporate commercial, you need to manage your time. One thing I do, which I have done, which has helped me all these years, is that I have a list, and I'm sure a lot of people do it, a to-do list. So at the beginning of the week, usually I do it on Sundays or early Monday morning, I sit down. I know all the work that I need to do. I list all of them. I have a sheet that I write them on. So the follow-ups I need to do, the calls. So I have a lot of people use Outlook too. So you diarize, okay, if you are very technology savvy, you diarize your meetings and your calls and your court attendance and all that. You can diarize. But for the things like drafting memos, I don't want to put too many things on my calendar. So I'll typically write those ones. So I write them on my to-do. So I know that, oh, for this week, these are the things I need to do. And it keeps piling up because every day new instructions come, right? So you have a to-do list and you're clear. Once I do it, I check. I check. So I know, oh, I'm done with this, I'm done with that. If I forget to put some work that the client has asked me to do, I forget to put it on my list, then I'll forget because you know how you're dragged into so many things. So writing down stuff is a great way to make sure that you meet your deadlines. Okay, so if you are not doing that already, it's something that you can do beginning of the week, or you can do it on a daily basis. Every day you check your to-do, make sure you update it and everything. You meet your timelines, your seniors, everybody will be happy with you. You will even be happy with yourself because it tells you, okay, I want to send these out on Monday, or my deadline I have 2 instructions today to send out. On Wednesday, I have another 2 instructions to send out. On Friday, I have another 2. So you structure everything. It helps you to manage your time. Okay, because sometimes the instructions come, you have so many instructions from different seniors within the firm, and you can be overwhelmed. But once you have your to-do list, you know how to negotiate your timeline so that you don't have too many deadlines in one day. If you have a deadline tomorrow, okay, today you can get another deadline tomorrow. So you structure your work, the timelines well, and it will help you. So that's something that you should consider doing. Proper time recording, that's really, record keeping. We all know, and I'm sure a lot of people do it already. If you are working on a transaction, we would simply have a file, and then we have an electronic folder as well. So we have a physical file and we have an electronic folder. It doesn't happen all the time that you open the physical file, but that's the ideal, okay, that you have a physical file. And if you need information, you can just grab the file. I'm still I'm a little old school. I like the physical. Even when I'm reviewing work, sometimes I like to print it and do the reviews. But if it's too time consuming, I'll probably just review on my laptop, and I do it once and for all, and it's fast. So I try to see what works for me, look at the time I have and see how much time I can spend. If it needs to go quickly, I'll review it on my laptop. If it's a big document, I'm likely to print it and go through it painstakingly. So record keeping, you keep your, as I said, open files, and then have your electronic folders, and attention to detail. I mean, you cannot overemphasize attention to detail. If you are sending emails, please read and read over. It may be a short one line, but a short one line that has so many typos, and you are sending to the clients will not look at you. Say your clients will probably think that a lawyer, if it's just one line that you have so many typos, if you have to write a written address to courts, I wonder how many typos you have there. Typos can create an impression. And so and typos is just one of the little things, but just always check and double check. And if you have friends, if you have a team of associates, and you have an associate sitting by you, or you share an office, you can draft an email and say, oh, can you just quickly look at it for me? And they'll come back and they'll say, oh, the S here is not supposed to be there. Meanwhile, you've read it like 5 times, but you didn't see that S. So it's something that you can do too. If you have friends, you have them in your office, you share an office, you just, kindly look at this for me. And it helps. When I joined the firm, the partner I was working directly under, he would type his emails and he would ask me, come and read them. And I'm thinking, who am I? Look at me, small fish from law school. I'm barely a month, I barely have a month of post experience. You're asking me to read a partner's email, but I took it in all my stride. It was a big learning experience for me. So I do that with my associates. You learn even writing style, some of these things you learn from there. So I do that. When I type emails, I'll call one of my associates, come and read it for me. Just not because I want you to correct what I have written, but maybe a few typos here. Senior, I think that maybe this word should be written this way. And they will usually come with very brilliant suggestions. Is something that you can think of. So we've talked about attention to detail, and I mentioned it's not just typos, it transcends typos. Just everything you're doing, might be mindful of the detail. Check, double check all the time. Don't take anything for granted. If a client comes to you with a question in your company's act, a question that you think you are familiar with, always go back, because clients come with different questions. One question on directors may come in so many forms that you go back to the law and you ask yourself, but this law, I've read it about 10 times. I've read it since I was called to the bar, but I'm looking at it today after 9 years and it looks different. And it's because of the way the client has asked you the question. So don't take anything for granted. Don't answer questions in a rush because you think that, I know this, I've done it 10 times. Always go back and go and check and look at it and be happy that I've checked this and it really is what it is. And so my last 2 points will be speaking up, and speaking up just generally. If you're in a law firm, you come and you are intimidated because there are people who have been there many years, seniors with a lot of experience. You think that they know more than you, and so whatever they say is what you should run with. No, don't do that. Don't be timid. But if I say don't be timid, don't be disrespectful either. Okay, go back or engage people with facts, with legal backing, with points of law. If you disagree, if you're senior, you've sent me work and I've looked at it and you disagree with some analysis, or you think there's some law, you go back nicely and say, Patricia, I think that you should look at this, or I've looked at this and I get a different meaning from this analysis that you've made. Can you kindly consider it? And when you do that, people always appreciate you, that you don't take things because someone who's 10 years at the bar has said, you just run with it. No, people in your seniors make mistakes. And so when they give work to you, or they come to you with, they've reviewed your work, look at it and make sure that you agree. If you don't agree, you should have some legal backing to it. And a senior will always appreciate you because then you are paying attention to the detail and you are thinking, you have a mind of your own. You are not just running with your senior. And you are more current, right? You just came from law school, or you are just 3 years, but you know the laws. You know where to find the laws, the sections, more than your seniors may have more experience. But it's something that we encourage in our firm a lot. We listen to people. We don't shut people up. When people have opinions, we want to listen to them. But we don't encourage people coming just, I think that this is how it should be. No, don't come to me, I think. Come to me, okay, based on section this analysis that we are doing maybe inaccurate. Can you kindly consider this section and look at it again? And then we can engage. So always go, not I think, but go with some legal backing, or go with something. go with something substantive, or something that can be substantiated, or something that can be verified. Okay, so that's another important thing. And then the key thing, feedback, accepting mistakes and trying to fix them. A lot of people say when they come for interviews, oh, feedback, I love feedback. That's what's going to help me to become a better lawyer. But when they come and you give them the feedback, you realize that no, some people are not able to take feedback well. I'm cognizant of the fact that when you're giving feedback, you give constructive feedback. We don't encourage people looking down on people and speaking to them, you know, in a condescending manner. We don't do that. Yeah, generally try to be very nice people. Will give you constructive feedback, and so you take feedback in good in the best way possible. Look at it as work and not an attack on your personality. Take good feedback, and if you take feedback like that, you realize that you improve, because if you take feedback and you work on it, you will never make that same mistake again. So if you're not making your own mistakes, that means you just keep improving, right? And so that's something that's very important. And another thing that you should take note of, when you do work and your supervisor looks at the work and reviews the work and sends you a red line version, please take your time and go through it. Because if you do not take your time, don't just go and accept all the changes and finalize and send it back to your supervisor to send to the client. Take your time. Even writing style is important. The way your construction, the choice of words, okay, the analysis, the way it's done. Take your time and read. It helps. It will make you better. And so that's something that I think that you should keep in mind. And that's really my last points for the day. So at this point, if there are any questions, please feel free to ask.
Hello, Patricia.
Yes, Aaron, I want to show my face.
Ah, nice.
Yeah.
Okay, so I suppose we can go into the Q&A.
Okay, yeah.
Okay, so thank you so much, Patricia. I mean, that was a very, very detailed presentation. Now, one of the interesting questions I have here is about the Chinese wall, in terms of ensuring that there is reduction in the level of conflict of interest, even when you decide to still proceed. So I don't know if you could dive in deeper into the entire idea behind Chinese wall, and how does it work beyond just big law, right? So when it comes to smaller firms as well, is it something that lawyers within smaller law firms can also apply?
Yes, I believe it can be applied. So one key thing I may have omitted to mention is the point on disclosure. Okay, disclosure. So if you are conflicted on a matter, so I was telling you about my husband who was conflicted because he couldn't take the instructions. His boss was already acting for the other side, so he couldn't take the instructions. And it's a small law firm. So in such an instance, what you would do is to speak to the clients, okay, both of them, and tell them that, look, lawyer A has acted for you in the past. This time around, you are on the other side. And this new client is our client. Would you be willing for us to take this new client where lawyer A would handle that client and then you will be handled by another client? And if it's possible, if there are new lawyers in the firm who possibly do not have any information or were not on the initial transaction for the other clients, it will be good to involve them. So you can, within the same law firm, you have 4 lawyers. 2 of them are involved in this new transaction, where one of them, or the counterparty, was an old or is an existing client of the firm. And this other new client also wants to use the same firm. What you can do is to give that new client to another lawyer who has no knowledge of your existing clients, who has never done anything for the existing clients. But one thing you need to do is that you need to disclose to both of them. And if, not if possible, by all means, get something written. Get something in writing, whether it's on paper with a signature and a witness, get it in writing. If it's an email, get it. So that if they, depend on how things turn out, and especially for the litigious matters, it can be dangerous. And so get it in writing. For the corporate commercial transactions, we really don't have problems. We get, once we disclose to them, they'll come back and say, oh, they are fine, we can go ahead and act for this other person. But for the litigious cases, just get it in writing. You first of all disclose, and if they say they are fine, have them put it in writing. And once they put it in writing, you can create the Chinese walls by getting people who have previously never been on the any of the have never helped or assisted with any work that has to do with their old clients. And then those people can act for the new clients that has approached you and that you intend to take the instructions from. So you can, it's possible. 2 things: disclosure and getting written confirmation, whether on paper or by email. Just get it. You can, and it's possible. I don't know if the answer helps.
No, I mean, I think it does help, right? I mean, particularly if one looks at it from a disclosure perspective, and also from getting the express consent of the client to proceed.
Yes.
Now, the second question I have here is, at the moment, I mean, I understand that ENSafrica has operations across multiple countries, and Ghana is just one of the offices. So, and so I'm asking these questions so that you can speak from that broad global ENS perspective. What are some of the key trends that you've seen that are different in terms of managing technology law transactions, whether you're advising a VC investing in a tech startup, or it's just a typical licensing that you're obtaining for a particular client? What are some of the key trends you're seeing in managing this set of new transactions that are coming on board?
Okay, that's a very wide question, but I'll try. Or a broad question, but I'll try. So with the fintech is relatively new for us in Ghana, and we have the central bank. There's a specific office that has been set up to regulate fintechs. That was not the case before. It was all under the central bank, but now a specific office has been created for them. So the trends in relation to managing some of these fintech companies. So one of the things that I can say is that for a lot of these companies, when they come to us or when they approach us, is really about making sure that they understand how our fintech laws work. Okay. Understanding and also knowing how the central bank deals with, or central bank, the processes that goes into licensing them. So just last week, we had a call with a potential client from Uganda, and they are an SME and they want to come and set up in Ghana. So we had a long call and we had to go through all the requirements that they need to comply with. I mean, the licensing process itself is not as scary. It's an arduous one, but it's not scary. It is possible. It can be done. We've done it. But for them, we need to, from the get-go, let them know that, look, we have very strict local content guidelines or regulations in Ghana. And so from the start, we need to tell them, look, you cannot front, and I'm sure fronting is a common term across jurisdictions, so people would know what fronting is. So we let them know what the law is and whether the regulators are enforcing or implementing the laws. Okay, so local content is one of the key things that we've been talking about, because we've seen a lot of our clients have trouble with local content because in the past they weren't regulated. We didn't have laws on payment systems. Okay, the payment systems law just came into force in 2019, late 2019. And so for people who were operating before 2019, who didn't have to comply with some of these laws, like the local content and the corporate governance issues and all that, it was a big change. Even though what we did at that time was to advise our clients that, look, we have laws that are going to be passed. And when they are passed, this is a likely implication for you. You would have to change your shareholding. You need some local partners on board. You need to change your board of directors. You need to get a secretary. You need to do all these things. And so for us, the way we've been managing them, especially for SMEs, is to make sure they understand the law properly before they make a decision to actually come and get a license. Because if you do not let them understand that Bank of Ghana does proper investigations, and if anybody's trying to front for you, it's likely that Bank of Ghana will find out. They would go into the market and look for a proper partner and not come with just anybody who will serve as a front for them. Because in other industries, it's happened and it hasn't benefited the country. So Bank of Ghana is on a very high alert, and we let clients know. So any proposal that they come to us with for licensing, we really scrutinize it. So in terms of management, everything else will be just like a regular company. But what we try to do is because there's a legislation.
Hello, Patricia.
Key requirements for them, the ones that we think that will be problematic. And I've mentioned the.
Okay, so thank you so much, Patricia. We lost you for a moment, but I think we understand what is being said. I mean, if I were to go deeper into the local content requirements in Ghana, and we could be on this call forever because of the very specific nature of some of those requirements. The fact that sometimes these requirements are not static. So for instance, you may be required to, in 2 years, meet a particular local content requirement, in 3 years, increase that to a particular percentage, and it goes on and on that way. I think the overall strategy around this for the government is ensuring that they have significant local participation in a number of these emerging areas, right? So it's very innovative, and the fact that regulators are also paying specific attention to implementing them, I mean, I think that speaks volume to the overall growth strategy of Ghana. So I'm going to ask one last question here, and so this person is saying, how much attention and importance should intellectual property due diligence be given in M&A transactions, specifically if it's a tech-related transaction? And perhaps a second leg to this is, okay, so the person is basically saying, Well, a lot of attention is given to corporate and legal due diligence, but it appears less is given to IP due diligence. So just to summarize that question, so how much attention or importance should be attached to intellectual property due diligence in M&A transactions that are tech related, as compared to the emphasis given to corporate and legal due diligence?
Okay, so it is not, that's a good question. We don't give it the needed attention, but I don't think that would remain the same. And I think with the birth or the way the fintech space is gradually going or moving, is going to change. The corporate and legal is, or the corporates is really like the main thing, corporate and regulatory. IP, you realize that it's really a small part of it, where they list all the intellectual property that the company has, and they indicate whether it's registered or not, or if they have some sort of software that they own. They will look at it and then they'll state that maybe they have this software, and then really that is it. But if you are, for instance, acquiring a payment systems provider in Ghana, that's would require, because really payment systems, the key thing or one of the important things that you look at are their systems, right? Their software, the softwares that they've developed to be able to aggregate or to be able to allow customers or merchants to do business on their platforms. They may not have any other assets. The only asset they may have is some technology or some software. And so if you are doing a due diligence, for instance, on a company that, a payment systems company, you are more likely to do a financial due diligence because you want to see what the value of that software is. So you do a financial due diligence, so value or evaluation to see how much that software costs, because that would impact the pricing for your acquisition. If you are going to buy a tech company, the software has to be valued, and that valuation would impact the consideration for the transaction. So with that, I don't know how much detail will go into it. If it's trademarks, for instance, you just list the trademarks, indicates when they were registered, and then also indicates if they've expired or when they would expire, and really that is it. But if it's a payment system or a fintech company, for instance, you're looking at the software, and for the software, you need to know how much, who owns the software for starters, and how much does it really, or how much it costs. Those are the things that you'll be looking at. But if I were to do a due diligence on the payment systems provider today, those are the things that I will be looking out for. We'll make sure we get an auditor or an accountant to do evaluation of the software, and also to see that the entity that we intend to acquire actually owns that software, because we don't want to be engaged in any battle on who owns it. You come and acquire the company, you realize that they don't even own that software, somebody else owns it. So those are the things that I'll probably be looking at if I were to do a due diligence, an intellectual property due diligence. But on a fintech company, the corporate is just a little part of it. That would be my key focus, because without that, the company won't be able to operate. So yeah.
Thank you so much, Patricia. So just a final question. I know I've been saying that for a while, but this is just for the young lawyers we have within our community, or even persons with more experience who are very interested in either deepening their existing competence or credibility in the tech law space, or interested in pivoting into that practice area. So what 3 advice would you give to persons within these categories?
I mean, to just be open and honest with your clients. If you are doing research, you quote the law, which we can all check easily. If you have to speak to a regulator, you check with the regulator. Don't go and put in a memo or an opinion that you spoke to the regulator when you have not spoken to the regulator. Don't go and say something that you have not double checked, because when they come back to you, it won't be, don't be known for that, or don't give anybody the opportunity to look at you in a certain way. If you haven't checked, you be honest and say, I haven't checked, I will check and come back to you. There's room for that. But you also need to be mindful of your timelines. But really just being open and honest about your work, trying to maintain the highest integrity as much as possible. I mean, and being open. And if you don't know something, because if you're a young lawyer, this is the time to make mistakes. As you go, your mistakes will be, some of them will be unpardonable. Some of them may be damaging for you, for your firm. But if you're a junior lawyer, you have the benefits of your senior review your work before it goes. So if there's a problem, it will be caught. But if you're a senior, or you're a senior associate or a partner, if I'm sending work, I don't have anybody to look at it for me. So I'll send the work. And so if there's a problem, it will come to me. But you have the opportunity to make mistakes, because some feel free, not feel free, do your best, but it's okay to make mistakes at this stage. Don't be known for that, but it's okay to make mistakes, because as you go, your mistakes, it won't be okay as you go in the law. So those are my few words that I can share. I can share in that. A key thing, please always check with the regulators. Look at the law, check with the regulators, and don't run with what the regulators say, because the regulator may be wrong. Look at it, form a view, have an opinion on it before you go to the regulator. And so if you go to the regulator and the regulator is, sorry, pardon my language, is bullshitting you, you can challenge what they are saying. And when you challenge what they are saying, you see that, look, there are holes in what they are saying. They would go and look at it again and come back to you, challenge in a nice, respectful manner. But you can only do that if you've also done your homework, you've checked the law, you are quite confident of your interpretation, you understand the law and you know what you're talking about. So you just go for further confirmation from the regulators. Don't go to them first before you go and look at the law. It's never the right way. They will mislead you all the time, because you don't even know who you are talking to sometimes when you go to the regulator. And if possible, try and send written. I know time constraints and all, but if you are not clear on something, if you have the opportunity, write to the regulator, let them come back to you with written confirmation. That way you just take the paper and say, look, Central Bank of Nigeria, this is what they said, oh, it's not me. But if you go and talk to somebody who's sitting at the front desk and they come back to you and they give you information, and you go and write it in a memo as if it's the holy word, and something comes up and you say, I've spoken to the Central Bank, but you spoke to somebody, secretary at the Central Bank, and not anybody in position of power. And so those are the things. I mean, I could go on and on, but I think our time is fast spent, so I will end here.
Thank you so much, Patricia. I'm sure if you were to give us a fee quote for this, we would have to find some dollars and send it over. But thank you so much. I think it's been a very detailed discussion this evening, particularly looking at the entire framework of managing complex transactions and even the simpler ones. On your last comment on engaging with regulators, I think that's very key. And, just to be certain that this is exactly what the position of the law is. I think what's also interesting and a growing interest among clients is how a client would have gone ahead to read the laws before asking you for opinions. And so you want to be sure that you exactly know what you're talking about, or probably even bring in something additional on board. So thank you so much, Patricia. And this recording will be shared with everyone. It will be available on our YouTube channel as well. And we're just really glad to have everyone come on board this evening. Thank you so much. Patricia, I don't know if you have any parting words you would like to share.
It would have been nice to hear people ask questions. I just hope that somebody has learned one or two things that they can apply in their life. That's all. And thank everyone for making time to listen to me.
Thank you so much, Patricia. We'll share a feedback form with everyone, and we will take that feedback and make sure Patricia gets it. Thank you, Patricia. Thank you, everyone. Have a really lovely evening, everyone. Bye.
Bye. Bye. Bye.